I'd like to welcome everyone to our 2022 Council Information Session. My name is Amanda Knight, and I am the clerk for the Township of Guelph-Ramasa, and with me is my colleague, Jenny Spice. She's my deputy clerk. You're likely here because you or someone you are close with are considering running in the 2022 municipal election. We hope that you find tonight's presentation interesting, informative, and helpful in deciding whether you want to run for council or school board trustee. Tonight I am joined by my fellow clerks from within Wellington County. They're located at the back of the room. I encourage you to connect with them after this session if you have any further questions. So just a couple of housekeeping items before I introduce tonight's speakers. This session is being recorded, and we are going to hold off on questions until both of our presentations are completed. So without further ado, I am honored to introduce our speakers. Our first speaker is John Mascaran. He is a partner with Aird & Bearless LLP in Toronto. He is widely regarded as a leader in municipal planning and local government law who appears regularly before municipal councils, committees, and public authorities and boards, administrative tribunals such as the Ontario Land Tribunal and Ontario courts. He's a certified specialist by the Law Society of Ontario in municipal law, local government, and land use planning and development. He's an adjunct professor at Osgoode Law School, where he teaches courses in municipal law and land use planning law in both JD and LLM programs. He is an author of 5 published books in the area of municipal and planning law areas, and an editor-in-chief of the national publications, the Digest of Municipal and Planning Law, and the Municipal and Planning Law Reports, and the co-editor-in-chief of the Real Property Reports. I am very much looking forward to John's presentation this evening. Followed by John is Linda White. Linda White was born and raised in Fergus, Ontario, and moved to Arthur over 40 years ago. She became involved in municipal politics in 1993 when she was elected councillor for the village of Arthur. She was elected county councillor in the year 2000 for Ward 4 and retired in 2018. She also was the village councillor for 3 years and served as deputy reeve for 3 years as well. She was elected as warden in 2004, which was the county's 150th year. Throughout her years as county councillor, she served as chairperson for roads and waste management and social services. She chaired Wellington County Police Services Board for 10 years. Linda also served on the Groves Memorial Hospital Board as the county liaison for many years and was a member of the building committee for the new hospital. Linda is a retired businesswoman, having worked with her husband in their business in Arthur for 37 years. She has 2 amazing daughters and 5 grandchildren. Presently, Linda is a member of the fundraising campaign cabinet for the Groves Hub, where youth in Wellington Guelph are empowered to take the lead in their own mental health and wellness journey. She also serves as a member of the committee that is raising awareness and funds for Alora House. Alora House provides safe housing and support for individuals who identify as women and who are victims of sexual exploitation and human trafficking. In her spare time, Linda enjoys traveling, golfing, reading, and spending time with her family. And I know Linda will be able to make her personal experience as councillor and warden very relatable. So with that said, John, the floor is yours.
Hey, good evening, everybody. Nice to see such a full room. I haven't seen a room like this in 2 years because I've just been doing video conferences just like you have. My wife said today you actually had to put on real big boy pants. And they don't fit nearly as well as I remember them. Thank you very much. I commend you all for your interest in coming out tonight to hear about this and for your interest in potentially being public servants, because that's what you may be signing up for if you decide to run for council. My presentation will be from, I think, my perspective. I've been a municipal lawyer, been a lawyer for 32 years. I've been a municipal lawyer really for about 31 of those years. I worked for a municipality for 11 years. That's where I think I cut my teeth and I got to see how a municipality works from the inside and working with council and other staff. In the last 20 years, or almost 20 years, I've been with my current firm giving advice to mostly municipalities, sometimes on the other side, but mostly municipalities. And I hope to bring some of that experience and knowledge and impart it to you tonight. I'm excited to hear from Linda White, who will probably give you an on-the-ground, real-life experience of what it is to be an elected representative, and Linda did it so well for 25 years. We will take questions, but as Amanda indicated, we'd like to wait to the end. And I'm sorry to do that, but I didn't want to be fielding questions and then telling you stories and then not leaving you with enough time for the questions later. So I'm going to start off my presentation with a number of quotes, and I just want you to think about them. The reason I'm putting them up there is for again, have a thought about what they say, and I'll have a couple of comments, and then I'll go into the presentation proper. So, P&I, a case that went to the Supreme Court of Canada, not once but twice. It actually went to the Supreme Court of Canada, same parties, almost on the same matter, slightly different, 2 years later. Justice LaBelle said this: municipal governments are democratic institutions. And I used to stop it right there when I teach to my law students. And I read the rest of the sentence and I thought, that really has some vibrancy. It really actually means something. Municipal governments are democratic institutions through which the people of a community embark upon and structure a life together. Just think about what that means. You know, one of the debates that I often have with my students is, what is a municipality? What's it supposed to do? Is it a mere service provider? Is it just supposed to provide services at the least possible cost to the taxpayer? Is that what it is? Or is it an actual place that provides an outlet, a vision, a path to embarking on a life together? So I really like that quote for that purpose. You can probably tell which camp I'm sitting on. Mr. Rogers, Ian Rogers, wrote this incredibly great work, encyclopedic work, called The Law of Canadian Municipal Corporations. First written in 1959 and then updated, significantly revised in 1972. While serving on the council, members are under duty to act in the best interest of the corporation and the citizens they represent. That would be the duty of any of you or your family members if you ever run for council. You must always keep in mind that you're there to serve the public interest and to ensure that the public interest of the corporation itself, because what is a municipality? Well, it is what I indicated before. It's a service provider, it's a government, it's an institution that structures how people operate in a certain community, but it's also a corporation. And that goes all the way back to the 1849 Baldwin Act, the first legislation here in Upper Canada that created municipalities as a form of corporation. They don't have a letters patent, they don't have articles of incorporation, but they are at law a corporation. Okay, so just remember that as we're going through some of these things that I'm talking about. Spraytech, a case that dealt with cosmetic pesticide use. The judge, Leroux Daubé, said, lawmaking and implementation are often best achieved at a level of government that not only is most effective, but is also the closest to the citizens affected and thus most responsive to their needs, to local distinctiveness, and to population diversity. Just think about that. That was over 20 years ago where that was said. Really fine language there. And that is, if you want to know the legal term, the subsidiarity principle. Not subsidiary, subsidiarity principle. That says, essentially, lawmaking and implementation are best achieved at the level of government that is closest to the people to do certain things. What does a municipality do? Again, just think about what is a municipality. I was listening to one of my colleagues who was doing something very much like this in another realm of the province earlier last week. And he said, do you know how many things municipalities do? And he said, if you can think of 70, you're doing phenomenally well. About 15 years ago, I did some work for the Law Society of Ontario, then the Law Society of Upper Canada, and we were asked to come up with what are the core competencies for a municipal lawyer. And I was asked to put together a list of all the statutes, the regulations, right, the laws that apply to municipalities. Do you know that municipal governments get their powers from over about 120 statutes? It's phenomenal. Most people think of them, and I'll show you a slide later on. Most people think, okay, there's the Planning Act, sure, for land use planning matters. There's the Municipal Act. There's about 118 other statutes that apply to municipalities. Okay? But then I'll also tell you that municipalities are creatures of provincial statute. What does that mean? And what does it connote? Finally, a case that you probably, here we go, about municipalities that are creatures of provincial statute. You probably all heard about it, went to the Supreme Court of Canada. Yes, I was talking about it ad nauseatum to people, and everyone wanted to interview me to ask about what I thought about this decision. It was the Counsel decision, the halving of Counsel decision in the city of Toronto, where on the eve of nomination day in 2018, the newly elected Ford government in Ontario decided, you know what, we don't think that the city of Toronto is working too well with 47 council members. Why don't we just create it, as a 25-member council? Right in the middle of an election. Right? Now, I looked at this and I was asked, what do you think about this challenge? I said, it has no legs whatsoever. Wow, was I ever wrong? It went all the way to the Supreme Court of Canada, right? And the Supreme Court of Canada evoked the common pejorative moniker for the municipality that it's only a creature of provincial statute. And you'll see the last line there. The province has, quote, absolute and unfettered power, legal power, to do with them, municipalities, what it wills, right? So just think about that as you're going to become, or potentially, a candidate and hopefully for you, elected office as a local council member. You're always going to be thought of as a tertiary level of government, one that has no constitutional protections. Because why? The federal Constitution here in Canada, the Constitution Act, was created to have two constitutionally protected levels of government, the federal government and the provincial government. And provinces were put under the dominion, under the purview of the province. So the province controls what municipalities do. It's always important to remember. So here's the outline of what I'm going to talk to you about. That was just a little bit of prologue. What's past is prologue, says Shakespeare. Municipal powers. What kind of powers do municipalities exercise? What are the roles and responsibilities of council, and how do they jive with municipal staff, the administration? What's a bylaw? How does it get enacted? What about meetings? What's a procedure bylaw? Why should you know what a procedure bylaw is? What about municipal accountability? Will you be looked at on an ethical, perspective? Yes, you will. What about freedom of information? What kind of things are dealt with there? Do you know that a councillor is entitled to be legally biased? Yes, I'll explain that in a moment. And finally, you will be, if you're elected, a fiduciary of your municipality, and that carries with it all of the obligations that a fiduciary has at law. A fiduciary, I'll tell you in just a moment, a little bit, is a trustee, and you have to act in the best interest of the body on which you're sitting on. You have a duty of loyalty and a duty not to act in conflict with the interest of the municipality and the council. Okay, so that's the quick outline.
So let's talk a little bit about municipal powers. I am going to be going through this quickly, but hopefully we'll have time, Linda, at the end to be able to answer questions. So please, we'd like to answer that. That keeps us flying by the seat of our pants, and we're happy to do that. So, municipal powers. The purposes of a municipality are set out in the Municipal Act, right there in Section 2. If you didn't know, and I've already said it, municipalities are created by the province of Ontario. Duh! They actually had to put it in the statute to make it known. Why? Well, to be responsible and accountable governments. Notice that it doesn't say independent, right? Because municipalities, in a sense, aren't, because the province rules the roost. For what? With respect to matters within their jurisdiction. So it's setting up an inherent limitation on the jurisdiction of municipalities. And a municipality is given powers and duties under this act, this is the Municipal Act, as well as many other acts, for the purpose of providing good government with respect to those matters. So when I say about those matters, you as members of council will not have the ability to have any direct influence on national defense, right? Money, you won't. Immigration, you won't. You may be able to deal with certain things independently, but you won't be able to deal with those sorts of things and many others, whatever's set out as exclusive jurisdiction under Section 91 of the Constitution Act. You won't have any powers there. Under 92, which is the provincial domain, the exclusive jurisdiction for provinces and territories, you may have certain powers, but that's only as a delegatee of the province. And the province can, as proven in the City of Toronto versus the Ontario Attorney General case, which I just showed you, province can come in at any time and just yank those powers away if it feels that municipalities aren't exercising them in a proper manner, or the province doesn't like the way you're doing it. Okay? Greenbaum, here it is. Justice Iacobucci said this: if you ever see this at the beginning of a judicial decision, well, it's telegraphing exactly where it's going, right? Municipalities are entirely creatures of provincial statute. That means they don't have the authority to do this. Here it was in paragraph, I think, 14 of the Greenbaum case. This was a case that dealt with licensing. It was in paragraph 2 of the Supreme Court of Canada's decision in Toronto and Ontario Attorney General. What this means is municipalities can only exercise powers that are conferred upon them, or that can be implicit on the powers that are conferred upon them by the province. So very limited jurisdiction. Here are some sources of authority, and I could have gone on, but in the interest of time, I just gave you some of the sources. The Municipal Act, it gives municipalities the powers of a natural person, broad authority powers, spheres of jurisdiction, where there's 11 itemized general realms of jurisdiction that a municipality can pass bylaws in. I'll just give you a sampling. Business licensing, animals, parks, recreation, culture, highways, all traditional municipal realms of power and jurisdiction. The Planning Act, you'll see that in Ontario there are two statutes. There's the Planning Act and the Municipal Act, the two main statutes that give powers to municipalities. In some provinces, there's only the Planning Act, and you have massive planning acts that are 1,900 sections long. Here in Ontario, we've divided it up, thank God, it makes it a little bit easier to read. Land Use Planning Authority, probably one of the more contentious and fraught powers that municipalities have, because the province has delegated most of its powers, and you'll say, hold on, but I hear every day MZOs, Minister's Zoning Orders, yes, the province can take back the power, right? Just like what I've said before. So the Planning Act, Land Use Planning Authority approvals are largely delegated to local authorities, municipalities and other approval authorities. This includes things like site plan control, development control, subdivisions, part lot control, consents, and zoning, probably the things that you've heard about. The municipality can decide where you can have certain uses and where you can't. And that's the zoning power, which have been delegated mostly to municipalities. Notwithstanding that the province has huge authority under Section 47 of the Planning Act to itself put in minister's zoning orders, and you've heard about that because there's a lot of contention about that. How is heritage protected? Well, by the Ontario Heritage Act, and anything that's not provincial can be protected by a municipality under the Ontario Heritage Act. Development Charges Act, where this is a taxing statute essentially, where a municipality can try to recover monies for the capital costs that it spends in order to provide infrastructure, highways, sewers, water mains, electrical services, libraries, parks, things like that. The Building Code Act, where the municipality essentially is the enforcement authority on behalf of the province for the building code. You cannot build anything unless it's very small, under 10 square meters, unless you get a building permit issued not by a municipality, but by a chief building official, independent authority. But municipalities are the enforcement arm. And finally, Fire Protection Act. Again, these are just 6 statutes that I've taken out of about 120 plus statutes. So there's some sources of municipal authority. The Tsui case that went all the way to the Ontario Court of Appeal says a bylaw is a creature of a municipality. As the municipality's authority is delegated by provincial legislature, a bylaw must be rooted in provincial authority. So there's many ways in which you can challenge the actions of a municipality. Whereas the province and the federal government have some inherent constitutional jurisdiction and protection, municipalities don't. So you can challenge municipal authority on many grounds. There was a beautiful paper written about 20 years ago by, he wasn't then, but he is now, Justice Perel, called The 10 Commandments of Municipal Bylaws. And it's a really terrific read for anyone who wants to understand what can't you do as a municipality. Well, there's 10 realms that you have to be really careful, and I always go back to that paper and look at it. And anytime someone says, we'd like to pass a municipal bylaw, and I want to look, okay, how do we try to bulletproof this bylaw? But the first thing that you have to look at is, where's the authority for it? Can you find it in the Municipal Act? Can you find it in the Planning Act, Development Charges Act, the Emergency Management and Civil Protection Act? Because remember when 2 years ago COVID was hit, a lot of you are wearing masks, that's when it hit, yes, March of 2020. And all of a sudden you had emergency states of declaration by the province under section 7.1, I think, and under municipal authority by the mayors, by the head of council in a number of municipalities under section 4. And you have to find some grounding, some foundation for municipal power in a provincial statute, okay? You're not just going to find it inherently somewhere. It has to be grounded in a provincial statute. It may be in a very general way, and there was a huge evolution in municipal statutes back when the Municipal Act 2001 was created. Before that, you used to have a long prescriptive listing of municipal powers, and all of a sudden it was turned on its head, and you have these broad realms of jurisdiction where a municipality can do pretty much anything it would like with respect to a municipal highway. Opening, closing, temporarily closing, maintaining, all those sorts of things. So, but you have to find its roots somewhere in provincial jurisdiction, and if it's not found there, it may be subject to challenge on the doctrine of ultra vires. Ultra vires, Latin for outside of the law, outside of the jurisdiction. Municipal powers. Well, in Ontario and throughout all of Canada, the way municipal powers are exercised and directed are through the Council. So I quote this case not because it's the most important or groundbreaking case, but I just like what it says. from the Ontario General Division back, 30 years ago. In Ontario, the decision-making power of municipalities is given to the Municipal Council, and it is to exercise those powers by bylaw. The council is the general agent for the corporation for all purposes and is the means whereby the municipality may bind itself to a course of action. I was having dinner with Amanda and Jenny and a number of the clerks before. We were talking about something called the discretionary enforcement principle that you may have heard, maybe not. That's a principle of law that has existed in Canada for about 150 years. And what it actually means is a municipality may pass a bylaw, and if it's a permissive bylaw, and there aren't that many mandatory bylaws, but I'll talk to you about one in just a moment. Municipality passes a permissive bylaw, it doesn't have to enforce that bylaw in any particular way, any particular degree, or even at all. Now, does that surprise you? That's been the law. Now, at least 3-4 times a year I get a resident that says, I want to hire you to sue my municipality, and I know where this is going. They go, my neighbor keeps parking and is in contravention of the bylaw and the municipality's not doing anything. Or there's a nightclub down the road or a pub and they play music really loud late at night past the curfew of the noise bylaw. I want to sue them. The answer is, you won't get very far if you're going to sue the municipality because the municipality doesn't have to enforce those bylaws. Now, the Municipal Act actually recognizes this through something called the self-help remedy, which means a taxpayer, any one of you, could step in the shoes of the municipality if the municipality is not enforcing its bylaw, and you can bring an application to the court and stand in the shoes of the municipality. Okay? Probably didn't know that, right? Now, so you can't generally, I say everything in general terms because there's always caveats, but generally you cannot sue a municipality for not enforcing its bylaws because it doesn't have to. There's a Supreme Court of Canada case, former Chief Justice Mccallion said, a municipality can take a wide array of factors into making any decision that it makes, including the passage of a bylaw or resolution. It can consider budgetary constraints, staffing limitations, financial constraints on the municipality. It can take all of those things into account. I've used that quote many times when someone comes to me and says, municipality's not doing what it's supposed to be doing. And I'm saying, actually it has. It's taken all these things into consideration. You may not like it that it's not enforcing the bylaw, but it doesn't have to. But that doesn't leave you without a remedy. So, again, it's the council that is the decision-making body. The entity that I think you guys are interested in possibly applying to be a member of. So, let's talk about roles in administration. Governing body, as I said, municipal council, most important decision-making body in the local governmental context. Council exercises executive powers. Yes, it makes decisions. We will require everyone who attends a municipal facility to wear masks during a pandemic, right? We require our employees and councillors to be vaccinated if they have to come into the council chamber, for instance. Legislative role, where council passes bylaws and resolutions, its own version of legislation. And quasi-judicial powers and functions. And you might be saying, what? Yes, sometimes council has to put on a different hat, and instead of being a council member, the council member actually sits as an adjudicator. It doesn't happen very often, but there are some instances in the Municipal Act where the council actually doesn't act as council per se, but as a decision-making body. So one example, council is faced with a report from an integrity commissioner on a council member having acted ethically wrong. And the integrity commissioner has found that the council member has breached the code of conduct. I'll talk more about this in a moment. And is recommending potentially a reprimand or a suspension of pay of the council member. Council acts as an adjudicative body in that case to make a decision on whether that happens. Development charges. Someone doesn't like their development charge that they have to pay on their development and may say, this isn't correctly determined, it hasn't applied the bylaw properly, and I'd like to file a complaint. And then that goes in front of council for a formal hearing. and council makes a decision as an adjudicative body. Now, it's an elected body. It's comprised of a mayor or a reeve or a chair, and in one case, a Lord Mayor, Niagara-on-the-Lake, and members of council. Councillors are elected at large, possibly, depending on how the system has been set up in your particular municipality. And I can't answer the questions for each of the individual municipalities here in Wellington County because they all have different systems. But as a member of council, you could possibly be elected large. That means municipal-wide. For instance, a municipality may say, we have 4 members of council and it's the first 4 members who get the votes for the council. Or it could set up a ward system where you run in a particular ward. And you do not have to be a resident in the particular ward in order to run in that ward. Question that I often get asked. The term of council, 4-year terms. It wasn't that long ago, it was only 2 years. There was a 3-year period in between. When I first started, it was 2 years for council members. When I first started being a lawyer, it was 2 years. Then it became 3 years for a period of time in the 90s. Was that right, Linda? And then it became a 4-year term. You can debate all day whether it's a good or a bad thing that it's 4 years. If you have a good council, gosh darn, it's a really good thing. If you have some egregiously bad people on the council, it is hell for 4 years. Okay? Local elections are held every 4 years. The term of the holder is until the successor comes in and is sworn in. Okay? Eligibility, every person who is qualified to be elected or to hold office is entitled to be an elector and who is not otherwise disqualified. And there are some disqualifications in the Municipal Act. Eligibility, look at this, you can be a resident or a tenant in the municipality, or your spouse can be a resident or a tenant in the municipality. Tenancy doesn't have to be just a residential tenancy. So you can live somewhere else and yet be eligible to run for office in a particular municipality, even if you don't own property, even if you don't lease property, but your spouse does. Okay, so I get asked that question. Well, this person's not resident there. So they're entitled to be elected to office. You have to be a Canadian citizen, at least 18 years old. And I think there have been a few people who have been 18 years old and elected to office and are not otherwise disqualified from voting. And again, there's a number of disqualifications. I won't have time to really go into too many of them. So some ineligibility, if you're a municipal employee, you can't be eligible to be a council member at the same time. You are entitled to run for office, but you have to take a leave of absence. This doesn't apply to volunteer firefighters. I get asked that question every election. Now, notice my first sub-bullet there. It says municipal employee, including non-employees. There are certain persons or individuals, including a municipal ombudsman, a municipal auditor, an integrity commissioner, who can't run for office, even though they are not employees of the municipality. You can't be a judge and be an elected municipal representative. You can't be an MP or an MPP, and you can't be a public servant within the meaning of the Public Service Act in Ontario. You can be disqualified if at any time during your term of office you cease to be a Canadian citizen, you fail to become a resident or a tenant of land, including the spouse of a tenant or a resident of land, if you're prohibited from voting, or if you've contravened the Municipal Conflict of Interest Act. And if I had had a little bit more time, I told Linda a story just before I started about a municipality that we recently defended on a $210 million claim. There are other ways that you can be removed from office. And there are some provisions in the Municipal Act, very little known. I didn't know them until I started to look at it and was faced with this lawsuit. So, what is the role of council? It's there. It's actually right in the Municipal Act. It's in 224. Let me say it this way. Many people have said it.
You, as council, if you become elected as a member of council, the role of council as a whole is the captain of the ship. You steer the ship. You tell the municipality where it's to go for the future. If you're the administration, you are the crew of the ship. And yes, you can think of Ben-Hur with all those slaves down there, rowing furiously at the bottom. You are the crew that are intended to get council to where it wants to go. And I'm going to talk about that in just a moment, because this is really important. You take an oath of office when you become a member of council. Section 232 of the Municipal Act says you have to take this oath, and you have to make 4 solemn promises. First one is that you truly, faithfully, impartially exercise this office to the best of your knowledge and ability, and I'll talk about a number of those things as I'm going through. The second one is really related mostly to criminal code provisions. Fraud, municipal corruption, breach of trust, where you will not receive any payment for any kind of vote that you are making as a member of council. 3 is something I'm going to spend a little bit of time on, that you will disclose any pecuniary interest, whether it's direct or indirect, in accordance with the Municipal Conflict of Interest Act, and I'll refer to it as the MCIA from here on. And because we are a constitutional monarchy, which I continue to rebel against, you will bear faithful and true allegiance to Her Majesty Queen Elizabeth II, the reigning monarch. Even though we've patriated our constitution, it's still in the Municipal Act. So, Municipal Council, what does it do? The powers it exercises. Powers have to be exercised by council. How? By bylaw, unless otherwise specified. Cardinal rules for how a municipality operates. What's a bylaw? A bylaw is the form of legislation that a municipality enacts, okay? If you know what a statute is, or a regulation is, that's what the federal government, that's what the provincial governments pass. A bylaw is a subordinate instrument, that's why it's called a bylaw. It's a delegated authority to an entity, in this case, a municipality, and the municipality passes a bylaw. I know, often they'll say the municipality passed the law. It doesn't really pass a law, it passes a bylaw. It's equivalent to a statute or a regulation. What's the role of the administration? Well, that's also set out in section 227. Just look at what it says. The role of the officers and employees of the municipality are to implement council's decisions. Okay? To undertake research and provide advice to who? To council. And to carry out other duties as required under the Act or as assigned by the municipality. Who would that be? It would be the council. So why is staff there? Staff is there to support council, to give it wise counsel, and to ensure that it's doing the right thing in accordance with the law. Okay? So again, just think of council with CIL, as the entity that is the captain of the ship, and the crew is the municipal administration. There are a number of statutory officers, and I mention this because it's really important. These entities, these individuals, offices, derive their authority from statute. And notwithstanding that they may be employees of the municipality or appointees of the council, these individual officers exercise independent authority with respect to certain things that they've been granted power under various statutes. So the clerk, for instance, we have a number of clerks here. No one can tell the clerk not to take notes at a public meeting. Clerk must take the notes at the public meeting. No one tells the clerk how to run the election because the clerk is the chief electoral officer. It doesn't matter that the clerk is the employee of the municipality. Council has no jurisdiction over the clerk. I often have to defend clerks. Aren't you happy, Amanda? I give advice to municipalities and councils and senior officers, and clerks are my friends. So are treasurers. I often have to defend them because they have certain responsibilities at law. The treasurer,
what's one of the cardinal rules of municipalities? They can't run a deficit, right? You can't tell the treasurer, no, you have to have it in red there. You cannot do that. The treasurer has to balance the budget at the end of the term. And so there's certain things that the treasurer must do, notwithstanding what the municipality would like the treasurer to do. The auditor, same thing. The integrity commissioner has independent authority under section 223.3 of the municipality. The chief building official. Remember I said before, the building permit, it's decided whether it's going to be issued or not issued by the chief building official, not by the municipality. And you'll see cases, I'm not going to pick on anyone, but the municipality of Pushlynch versus the municipality of Pushlynch's chief building official. Yes, it happens. Sometimes council's not happy with what the chief building official makes a decision to do, but that's the chief building official's independent decision to make. Same with the fire chief. Fire chief has certain responsibilities under section 6, even though it's council that appoints the fire chief. If the council doesn't like what the fire chief is doing, well, what's the answer? You repeal the appointment, you revoke it. Same with the chief building official. But you cannot tell them what to do in certain realms. So the distinction between council and staff, Mr. Rogers again from a different source, while it is council's role to make decisions on policy, to make rules that govern the municipality on matters within its jurisdiction by bylaw or resolution, it is the staff of the municipality who will carry out the policies and ensure that the bylaws are made known to the public and enforced. Okay? A little more pointed, the prescriptive literature offers clear, if not always attainable advice. Politicians have a clear leadership role in policy setting and must stay out of administration and management. That's really good words. I'm an integrity commissioner for a number of municipalities, and I actually had to do this. I know, I used to use it as a joke. So what I say here is, you don't micromanage the staff. You retain staff, professional staff, and you rely on their skills and their knowledge and their experience. You don't go drive the Zamboni at the ice rink, okay? And I always used to say that as a joke, and yet I got a complaint 2 years ago. My colleague Laura Dean went and investigated it. There was this running feud, and I won't tell you which municipality, but there was a ferry to get to the island. The council member did not like what the ferry master was doing and took over the role. And we actually had to investigate, and we said that the council member exceeded the jurisdiction and acted in contravention of the code of conduct. So just remember, you as elected officials set the policy, you set the programs, but you do not dive into the day-to-day operation and activities of the staff. That's what you have professional staff there to do. You have one employee essentially when you're council. You look after the city manager, town manager, the chief administrative officer. That is your one employee. And that person is responsible for the administrative arm. So that's, you don't interfere. And that's actually under statute. Section 228 of the Municipal Act says that the chief administrative officer is responsible for the effective and efficient control of the administration of the municipality. So just remember that. You don't step in and take over the role of staff. You have staff there, and you don't direct them. You as an individual member of council don't have that right, and I'll get to that in a moment. There was a judicial inquiry in the town of Collingwood. Former Associate Chief Justice Frank Morocco presided, and he said the province of Ontario should amend the Municipal Act to define the roles and responsibility of individual council members. So I showed you that section 224 sets out the role of council, and 227 sets out the role of the administration. But there's nothing in the Municipal Act that actually tells you what the role of an individual member of council is. Now you have certain guides, including the Municipal Affairs and Housing Guide to, can't remember what it's called, Guide to Municipal Council, something like that. It's a really good source, and it basically says there's 3 responsibilities that council member has. 1 is a stewardship role, 2 is a policy maker, and 3 is a legislator. okay? But it's not set out, and that's a problem in the Municipal Act. And Justice Morocco has recommended this. I think this is a really good recommendation. It'll probably take 7 years before the province looks at it. So important is the interaction between council and staff that there is a policy that's mandated. Every municipality must establish and maintain a policy dealing with council-staff relations to set out who does what. And often you'll see that, again, council is the policy setter. Council as a whole is the policy setter. And staff act on behalf of council, but staff have certain roles, and there's certain mutual respects that have to follow. You have to work together, okay? Linda will probably have something to say about that. Okay, now why am I talking about meetings? Well, be prepared that if you're going to be a member of council, you better like going to meetings, because that's how you conduct your business. And in Ontario, we have something called the open meeting rule. And it's set out in section 239. All council meetings and all committee meetings and all meetings of local boards have to be convened, held, and carried out in an open public forum. That means everyone gets to see what you're doing. So your business is out for everybody to see. The open meeting rule is a requirement for all meetings of council, including committees and local boards as well. Local boards, of course, are special purpose bodies created mostly by municipalities, but there are some special purpose boards created by statute, the Police Service Board, Public Libraries Board, Boards of Health. The purpose, of course, is to ensure open and transparent exercise of municipal powers, and, of course, a bylaw, which is the legislation that you can enact, can only be passed at an open public meeting. Right? That's why meetings are important. Famous case, London versus RSJ Holdings. The democratic legitimacy of municipal decisions does not spring solely from periodic elections, but is also from a decision-making process that is transparent, accessible to the public, and mandated by law. A very famous case that went to court back in 2006, 2007. My firm had some involvement in that. Brantford and Montour case that dealt with, again, a closed meeting. The open meeting rule has two basic important underlying purposes, rationales: increase public confidence in local government and prevent secrecy in municipal decision-making. Now, probably some of you, if you're interested in local government, have probably seen a council meeting, and you're probably going, what's this open meeting rule? I see council going in camera, i.e., in the absence of the public. Yes, it is allowed. I'm getting ahead of myself. It is allowed. There can be instances where council can go and convene itself into a closed meeting. There are 14 specific exemptions set out in certain sections of section 239, and it depends on the subject matter. Some of them are mandatory, only 2 of them are. Almost all of them are discretionary. And let me say to you, there are instances where it is important and it is imperative that council does convene in a closed session to hear certain advice given by its staff and certain things, and is entitled to have certain debates. I'll give you one, for instance. Municipality would like to purchase lands. Would it make any sense, would it be in the public interest if that discussion was carried out in an open public forum and council has to disclose the ultimate upset limit that they're willing to pay? No. Same thing on the sale of land. What about solicitor-client privileged advice? As a client, a municipality is entitled to retain a lawyer to give advice on very sensitive, controversial matters. Would it make any sense to have that in an open public forum? Probably not, because you're going to be conveying your litigation strategy, maybe some of the shortfalls in your argument, to anyone that's listening, including potentially people who are going to sue the municipality or who are already suing the municipality. right? Litigation matters. Personal matters about an identifiable individual. Your CAO has been accused of sexually harassing young female staff. Do you really want to have that discussion in an open public forum? Probably not. There are good reasons. They're all discretionary except for two. I'm not even going to talk about the two because they're very specific. So you are entitled to go in camera on certain things. In general, both the courts and the Information and Privacy Commissioner have interpreted the rules for going in camera as being very narrow and restrictive. That's the reason being that most things should be in an open public forum. Procedure bylaw. Read it if you become a council member. You need to know how meetings function, right? The purpose of a procedure bylaw is to govern how a meeting is called, what the place of the meeting will be, how the meeting will proceed in accordance with certain rules and procedures. Otherwise, you'd have chaos. The procedure bylaw is to give some order and standing to things that happen at a council meeting. You know, you'll see if you attend a council meeting, there's a call to order, the mayor or the reeve or the chair says we're here at a council meeting. There'll be an agenda, there'll be a certain process right at the very beginning, very close to the top. Might be a statement or a request for anyone who'd like to declare any pecuniary interests. I'll get to that in just a moment. And procedure bylaw also says how notice shall be given of meetings. Very important for the public to know. If you're not giving notice to people, how will they know if there's a meeting to be held? So it's a mandatory bylaw. You won't find this in many statutes. It's one of the few mandatory bylaws that every municipality has to have. Has to have a procedure bylaw that governs the calling place, procedure, public notice of meetings. It may allow for electronic meetings. That's how councils survived during the pandemic, through electronic meetings. Otherwise, what would council have had to do? Would have had to meet in contravention of probably social distancing and other issues, and pass a bylaw to delegate authority to somebody to do certain things because it wouldn't have been able to meet and to carry out the large business of council. The day-to-day administration could still have been carried out by staff, but the large policy setting role wouldn't have been available for council to carry out. Quorum. What is quorum? Well, 237 says a majority of the members of council are necessary in order to have a public, proper meeting, a valid meeting. There is a recalculation of quorum when people declare pecuniary interests. Most people don't know this. A council can go down, no matter how large, to only 2 people to make a decision. And it happens. It doesn't happen very often in perhaps this area. It happens up north a lot, right? It's the mine or the quarry. It's the only business. And the members of council may work for the quarry. Their spouses, their children, their parents may all be working or somehow related to the quarry. So sometimes you have this issue where a large number of people on council are declaring pecuniary interest, and all of a sudden you can't get a majority. You have a 5-member council and you can't get 3 people because 3 people have declared pecuniary interest. You can go down to 2. You can't go down less than 2, which is a situation that I had, where 8 out of the 9 members of my council were alleged to have pecuniary interest. So what did I do? Luckily, there's a provision in the Municipal Conflict of Interest Act you can apply to the court. So I made an application to the court. There haven't been too many of these made. And I had a very good judge, Justice Fred Myers, one of the most brilliant guys I've ever seen, who said to me, Mr. Mascaran, so hold on, these council members are being sued, and you're asking me to allow them to still make decisions because the city itself has been sued. And I said, you're right, Your Honor. And he said, how can I trust that they'll make the right decision and won't leave the residents holding the bag on all of these millions of dollars? Like they get out of it themselves, but they leave the municipality holding, the residents holding the bag. And I said, you know that persons who are disabled or people who are incapacitated have to go to the court to get approval. And he says, so is that what you're proposing? I said, yes. And where's my authority? I said, it's right there in the Municipal Act, Municipal Conflict of Interest Act. You can impose conditions. And he did. And he imposed conditions that we could not settle the matter unless we went back in front of him and he approved it. And so that's what we did. And we actually got a decision a couple of weeks ago where he dismissed this large claim against the municipality. I want to talk to you about accountability and transparency. It is in the news. Probably everyone has now heard about some of the really atrociously bad behavior of members of council throughout Ontario. Kincardine, someone uttered the C word against a female member at a council meeting, which was heard because it was picked up on Zoom. Rick Shirelli, the embattled council member who, yes, is still in office in Ottawa, apparently was asking his admin assistants to do something that was very unsavory when he was asking her to go out and wear high heels, short skirts, and no bras. Okay, this is atrociously bad behavior that's been occurring in municipalities. And you're asking me, how come these members are still members of council? That's because it's next to impossible to get a member removed from council. It really is. Does anyone remember the reign of Rob Ford in Toronto? Heck, he was a crack-smoking mayor on the cover of the Globe and Mail, and yet he remained mayor throughout his whole term. Right? Now, council did what it could. It stripped him of a lot of his powers, his discretionary powers, but he wasn't removed from council because it's next to impossible to remove a member of council. Now, there's a private member's bill at second reading at Queen's Park that is seeking to give integrity commissioners a little bit more authority to potentially remove members of council, like a Rick Shirelli perhaps, who have acted egregiously badly, and not just give them a little slap on the wrist. There are a number of accountability officers that have been put in place. I'll just leave you with that, accountability systems. This all came out of a public inquiry back in the early 2000s in the City of Toronto. Madam Justice Bellamy presided, and she issued a number of recommendations in a big 4-volume public inquiry report. Every municipality has to have a code of conduct. Okay? Every municipality has to have it and has to at least cover these areas. Gifts, benefits, and hospitality, respectful conduct. You see how this issue keeps coming up? Why? Because it's a problem in Ontario. It's a problem really all across Canada. I was asked a couple of weeks ago, I was on a TV show, and they asked me, has it been getting any worse? And there was a reporter from the City of Ottawa who said, yeah, it's really gotten worse. And I said, actually, I've been a municipal lawyer for 30 years. I've actually seen this stuff really been carried on for about 30 years. And it's the bad people. And I don't want to make it sound like I'm saying all council members are bad. That's not the case. I've seen some really terrific people. In fact, most people go into it for the right reasons. There are always the bad apples, though. So, respectful conduct, especially relating towards officers and employees, you're going to be looked at. Confidential information. You're going to be given information as a member of council that other people will not get. Most of it you'll be getting through closed meetings. The cardinal rule is you do not disclose that information to anyone unless council authorizes you. You cannot take it upon yourself to say, I'm going to go because my residents need to know. No, that doesn't work like that. Council is giving you certain information in an in-camera meeting that is not to be disclosed. That is one of the worst things that you can do. You owe a fiduciary duty to your members of council, to the staff, and to the residents. You do not disclose that. That has to be covered off in the code of conduct and the use of property of a municipality. Okay? Integrity Commissioner. Integrity Commissioner is the ethics czar. As I indicated to you earlier, we act as Integrity Commissioner for a number of municipalities. We look after the application of codes of conduct, other ethical policies, the Municipal Conflict of Interest Act, and I'm going to get to that, and we can have an enforcement arm, which is that we go and investigate when someone makes a complaint, or we can also seek to try to prevent breaches by giving advice to members of council. And the reason I put it in red,
on the screen, if you can see, is because this is new. Numbers 3, 4, and part of 5 are all new. Integrity commissioners were given much greater authority through Bill 68 3 years ago to give specific advice to members of council in order to prevent them from possibly acting the wrong way. Now, whether they come and ask integrity commissioners for advice is a whole different thing. I've recently seen the public actually putting pressure on council members to go and seek the advice of an integrity commissioner, something that's quite effective, especially in an election year. Integrity commissioner has broad, very broad investigative powers. Look at number 3, the second subsection. Municipality shall give the commissioner such information that the commissioner believes is necessary for an inquiry. Yes, I've actually had to go to the IT person and say, I'd like to see the emails that were sent between this time and this time because I think there was a breach of confidentiality. I'd like to see the phone records. Integrity commissioners can do that. Okay, and it's not an excuse to say, oh, I'm going to use my own phone. Integrity commissioners can get to that as well by constituting themselves as a public inquiry commissioner. Integrity commissioner has entitlement to free access to any kind of information, any records that a municipality may have in order to conduct an inquiry. Very broad investigative powers. We're dealing with this now. We're acting for a number of integrity commissioners on challenges to their jurisdiction. And the courts have said very clearly, significant autonomy an integrity commissioner has. Integrity commissioner, by the way, neutral and impartial. I don't go into an investigation looking to hammer a council member or a local board member. I don't go in trying to absolve them and get them off the hook. I go in to do my job. I investigate and I make findings and then I report to the council. And it's the council that makes the decision on whether to impose a penalty or a remedial measure. I'm astounded by a number of councils that say, I feel very uneasy about doing this. I'm acting as judge against one of my fellow council members. Well, that's too bad. That's what you do. That's what the law says. Now, if you don't like it, then delegate those powers. I've been delegated those powers. I'm proud to say that 8 of my municipalities trust me enough that they've said, you make the decision. Maybe it's like you make the decision, see how you like it. But they've given me the authority to do that. Now, that's not the normal. Council should govern itself and its own members. And you know what? It should stand behind the integrity commissioner who is only coming forward as an impartial, neutral person. I was telling a story at dinner where one of my municipalities, because the political winds were blowing a certain way, decided that they were not going to adhere to what I was telling them about really some pretty bad conduct by its mayor. And they thought they could get away with it. Well, I wrote my annual report, and the comment that was picked up by the media was, Council has abdicated its ethical responsibilities. And now I stand by that. You know what that got me? It got me a complaint to the Ontario Ombudsman, and it got me a Law Society complaint. And the Law Society and the Ontario Ombudsman thought so much of those complaints that it didn't even ask me for an interview before dismissing them. So significant autonomy to integrity commissioners. Try to make a friend of your integrity commissioner as opposed to an enemy. As I said, integrity commissioner can give advice. The advice has to be in writing, but you have to ask for it in writing. Why? It makes absolute sense. You don't want to have well, I thought they were asking me this and I gave the advice on that. No, I asked them this. So it has to be in writing and the advice has to be given back in writing. Just this morning I did this. Now I'm going to go through this quickly. The Municipal Conflict of Interest Act, probably one of the most important statutes that you should know. The granddaddy of all municipal accountability statutes, goes way, way back. It's one of the solemn promises and attestations that you take when you make a declaration of office that you will disclose a pecuniary interest in accordance with the Act. It sets out a framework where you are entitled to have a conflict at law. You're entitled to have a financial interest with business that municipality deals with, right? You may be a business owner in the municipality. Let's just say, for instance, you own a printing company and you
know that the municipality is setting out an RFP, a request for printing services. You as a member of council are allowed to bid on that. There's nothing wrong with that. Are you entitled to vote on it when it comes to council? No, that's the no-no. So the Act sets up a scheme where it's okay if you have interest in the municipality. It's actually set out in the principles. And it says it's a good thing when people have roots in the community, when they have a business or a profession, or they, their kids are there, or their parents. Nothing wrong with that. You just have to know how to deal with it when the decision-making matter comes before council. And what do? Well, if it's a financial interest, and by the way, they use the word pecuniary, in case you didn't know what it means. It means economic, financial, monetary, okay? So at the bottom there. Cooper and Wianco, a case from Georgian Bay. What constitutes a sufficient pecuniary interest to trigger the obligations under Section 5, and I'll tell you what those are, will not necessarily be demarcated by a bright line. So there's no bright line test here. You have to figure it out. You have to pay attention to the agenda and what's on the matters that council is going to be considering. You have to determine, do I have a financial interest in this? Does my spouse, my child, my parent have a financial interest? Gee, does my employer, is it my employer that's coming here, my partnership, or some other entity? Okay? Here are your obligations. If you have a financial interest in anything that's coming before council or a committee, you have to, 1, disclose it. 2, you cannot take part in the discussion, and you can't vote. Pretty obvious. C, number 3, you can't attempt to influence the voting in any way, before, during, or after. Now you might say, what? Why does it say after? Like, if it's at council, that's because this also entails committees, right? Something may go to committee and then still go to council. You can't go and talk at committee if it's going to be at council, okay? So you have to declare your interest, and then you can't participate, vote, or seek to influence the voting. There's also part 2 here. This is called the Hazel Mccallion Amendment. A few years ago, Hazel Mccallion, the long-standing mayor of Mississauga, there was a judicial inquiry. It was alleged that she was declaring pecuniary interest at a council meeting and committee meetings, but behind the scenes, she was doing what she could to put forward a hotel and convention center complex in the middle of Mississauga, something that she had talked about for years. All fine and well, except her son, Peter Mccallion, had an equity interest in a entity known as World Class Developments. So the question came, hold on, she said, I declare pecuniary interest. And Justice Cunningham, who presided over the judicial inquiry, said, doesn't end there. You have a common law right, an obligation not to act in your own self-interest, or those that you may benefit, like your own family. This says you can't seek to influence staff behind the scenes. So just because something isn't before council, the decision is with the clerk to make, or is with the CAO to make. You can't go and seek to influence them if you have a financial interest, and then step away council. A direct interest, just very quickly, what is it? It's a direct interest that you have, okay? And it can be positive or negative. You stand to make money, you stand to lose money, okay? Potential interest may be included in this. An indirect interest is where you may have a corporate interest. You may be a partner of someone's coming in front of council asking for something, or you may be an employee, right? Or, look at the one that, the 4th sub-bullet, you're a member of a body. Body is not defined. The Court of Appeal says it's been given its broadest possible connotation. So, you're a member of a church, a synagogue, a temple, a mosque, and you have that place of worship come before council. You're a member. You may not be able to deal with it if there's a financial interest for that place of worship. Or the Rotary Club, or the Lions Club, the Boys and Girls Club, whatever it is. Beware, because a lot of you probably have interest in the community. You've probably already given public service, right? And that's why you're probably interested in being a council member. Just be aware of that. Okay? Those are indirect interests. And then if that wasn't enough, any direct or indirect interest of your spouse, same-sex common law, a child, a minor or an adult, or a parent, if it's known to you, is deemed to be your own interest. So you have to be careful. You can be trapped in all of these things, right? There are 11 specific exemptions, there are 9 specific exemptions, 11 exemptions overall, 2 general ones, the ones that always come up and council members always defend if there's ever an application. There's an interest in common with electors generally. By the way, electors generally, that's defined. Interest in common with electors generally is actually defined. It doesn't mean the municipality as a whole. It can mean a much smaller area. Or it's so remote or insignificant as not likely to influence the vote on the question. Okay? There's a partial exemption if you are a member of council and you have an integrity commissioner report in front of council and the report recommends that your pay be suspended. You are entitled to go and speak. This is the Rob Ford amendment. There was a lot of criticism that said, hold on, he wasn't allowed to speak to the integrity commissioner's report that required him to pay back $3,150 that he had illegally and properly solicited. He has to be able to meet his accuser, right? And so they've added this. The one thing here is members can speak, they can make submissions, you just can't vote on it, okay? You have to make a written statement of disclosure at the meeting or as soon as possible thereafter. And the clerk has to keep a record of this. Penalties, what can happen? You can be removed from office. We have an application to the court. Actually, it was just argued last week by my partner. We were acting on behalf of Integrity Commissioner who brought an application to court to get a member dismissed, removed from council, and disqualified for 2 years. The last 2, the ones in red, are 2 new powers that have been given. So significant powers. There are some considerations. Did you take reasonable efforts to prevent the contravention? Did you disclose the pecuniary interest and speak to the Integrity Commissioner, get advice and follow the advice? If you do one of those 2 things, you're going to get off. Ask your Integrity Commissioner if you have a concern. The Integrity Commissioner is mandated to give you advice. Was it committed through inadvertence or by reason of an error in judgment? Okay. Freedom of information, I'm going to go really quickly. Because you're a member of council doesn't entitle you to any greater knowledge of information in the municipality. In essence, you are treated as any member of the public if you want information. The person who makes decisions at the municipality is the council, is the head of the institution. Council generally delegates that authority to the clerk or a privacy officer, and that person has to make decisions, not whether you're a member of council coming in demanding certain information. They have to make the decision in accordance with the Municipal Freedom of Information Protection and Privacy Act. Dual purpose, there's the freedom of information part, and there's the protection of privacy. Every person has a right to access unless it falls within one of the exceptions. And again, as a member of council, you cannot go and demand that your clerk or privacy officer disclose information to you simply because you are a member of council. They are not required by law to do that. So treat them with some modicum of respect because they have statutory obligations that they cannot deviate from. Okay? Bias, I said this at the beginning. You are, as a member of council, entitled to have inherent bias. Now this goes against the rules of administrative law. Rules of administrative law says, are you making a decision on something? Then you cannot even have a reasonable apprehension of bias. The courts have recognized that as a member of council, you are a representative of the community and you're entitled to form opinions and actually to propagate those views in front of council, right? You see this all the time. I'm against this development because my constituents don't want this development to proceed. You're entitled to do that. That won't create a bias. Just remember this. Please take this advice. The one thing that you cannot say if you're going to be making a decision at council is, I've made up my mind and it doesn't matter what you say, I'm not going to change it. Because all of a sudden, you run into 2 cases, Old St. Boniface and the Save Richmond farmland
case that says if you are no longer capable of persuasion, and believe me, I've had to run into this because council members say to the media, I'm not going to change my mind, they've disqualified themselves from dealing with the matter. And people will try to trap you into saying that, so just be really careful. You're allowed to have the bias, you just have to say that you're amenable to persuasion. Say it with me, you're amenable to persuasion. Finally, fiduciary duty. I'm going back, La Bay and Blind River from many years ago. A member of council stands as a trustee for the local community, right? You have fiduciary obligations with the electorate, with your own members of council, to the corporation. You have a duty of loyalty. It encompasses an avoidance of a conflict of interest and duty, and an obligation not to profit at the expense of the beneficiary. So you can't get into your business as a member of council to self-aggrandize yourself or to profit in any way. You have a responsibility to act in the best interest of the electorate at all times. Why? Because you are a fiduciary. My conclusions, and I'm now going to say, you're elected, congratulations, way to go. Remember, voting day, October the 24th this year. If you get elected, you're only councillor-elect that day. You then get sworn into office. You have to swear the declaration of office. You have limited powers and responsibilities, okay? You have powers only if you act together with a quorum of council. So you have to do a number of things. And these are my sorts of quick things to be aware of. And Linda will speak more from her life experience. You have to read a lot. Agendas are really thick. You have to attend many, many meetings. Please listen to people. Don't always think you have to hog the mic and bogart it, okay? You have to compromise. Remember, you can only make decisions with the majority of council to make things move ahead. So you have to compromise your views. Many people don't understand that. Empathize with all views, not just special interest groups. Just because a particular segment of ratepayers voted you in, you have a responsibility to all of the electors in the municipality, even if you're a ward councillor, okay? You have to act with integrity at all times, not just when it's convenient for you. And finally, you have to always seek to build consensus. Try not to divide the room. Try to enhance the views and work with others. That's it for me. I look forward to listening to Linda, and I thank you very much for your attention. I will be here to answer questions. Thank you.
Good evening. Nice to see everybody here tonight. And it's a pleasure for me to be talking to you tonight. As you've heard, my name is Linda White. I live in Arthur, and I served the public on municipal and county council for 25 years. First and foremost, I want to emphasize to you the word served. I was once at a conference, and the motivational speaker was Dick Butkus, who was the coach of the Chicago Bears for many, many years. And his opening line at that conference was, "It used to be that the politicians were there to serve the people. Nowadays, the politicians expect the people to serve them." That statement stayed with me for many years because I didn't want to be that kind of a politician. I was there to serve my community. So, saying that, the reason I'm here tonight is to talk to you about what it means and what it takes, and this is my opinion only, to be a counselor for either the municipality or the county. And I'm talking, when I talk about council, I'm talking both county and municipal. So the decision to serve on council should not be a frivolous one. I would hope that seeing you here tonight, that you've thought long and hard about the decision that you're ready to serve your community. If you are considering running for this very important position on only one issue, please reconsider. Even if you want to see a bridge built somewhere or you want to see some traffic slowed down, there are many, many issues that you will need to make important decisions about. You should not even be considered running if you do not have your family's support. The time you spend preparing for meetings and the time you spend at meetings will take away from your family life. It's a job, albeit it's a part-time job, but one that you need to be dedicated to. My husband and my daughters were my rock, always supporting me and listening to me when I mulled over many, many decisions that I had to make. Many times, George, my husband, would go into the local coffee shop to have his morning coffee, and he would be confronted by various residents about decisions that I had made at council. I remember when the controversial roundabout was voted on for Arthur, and George took all the negative comments in his stride, very seldom commenting, which was really hard for him. My daughter, who also works in Arthur as a nurse practitioner, was hounded about the decision that had been made. At the time, the roundabout wasn't the perfect answer, but it was the safest for that area in Arthur. So I just want to let you know about how things can get misunderstood. I want to tell you a little story about being involved with the building of the new hospital here in Centre Wellington. I served on the Groves Hospital Board for many years as the County Council liaison. I'm going to regress a little bit when I tell you how fortunate we are here in Wellington, especially in Centre Wellington, to have received the okay to build this new hospital. I was at a conference in Toronto, and I am going to talk to you a little bit about conferences. And some colleagues and myself had run into John Wilkinson, who at the time was the MPP of North Wellington and a member of the Ministry of Health. He had just received notice that he could let us know that the new Groves Hospital was a go. We were all ecstatic. The news traveled quickly, and the province let us know that the municipality had to raise 10% of the building costs. Through much negotiation and discussion, the county councillors voted in favor of donating $10 million in cash and in lieu for the building of this new hospital. They also decided to donate to the Palmerston and Mount Forest hospitals for the new builds that they had on the books. This was a situation where the councillors worked together for the good of the community. I also must tell you that if it wasn't for MPP Ted Arnott, that this hospital would never have been built. He visited the Ministry of Health's office almost every day to check on the build. Anyway, back to the misunderstanding. So rumors swirled about the new hospital, about bed counts, services, etc. for the new hospital. I'm sure you heard and read about them all. And my family was pounded with comments, mostly negative, about the new build. They took it in stride. I was proud of how they handled the negativity. But that was a situation where your family needs to be behind your decision to serve the community. My very first county council meeting, I was taken under the wing of three very knowledgeable veteran councillors. John Green and Carl Hall from Mapleton, and Bob Wilson from Centre Wellington. Their advice was simple. Listen to what is being presented. Don't jump in until you understand the issue. Being quiet gives you the opportunity to hear the words, the tone, and the meaning behind the words. Good leaders are good listeners. Effective listening helps to resolve conflicts, build trust, inspire people, and strengthen the team. It often requires you to bite your tongue, and from my personal experience, I know that can be hard to do. I also know that the results are well worth it. I did my job as councillor with a few things in mind, that being building relationships, playing as a member of the team, and being emotionally mature, which at times was difficult for me. Never underestimate the value of building your relationships with each other and with your staff. And John talked quite a bit about working together with your staff. You must be ready to invest time and energy from the get-go. Disrespect, contempt, and personal attacks create unhealthy relationships that undermine your time in government. If you wish another councillor to fail, then everyone fails. Good relationships and sound policy serve your community. Don't ever forget that a healthy council knows that you were elected by the public as an individual, but that you all must work together as a team. Being an effective team player means you can advocate for your own position on any item, but you must be open-minded about the position of others. It also means you need to work constructively with others, and you can't dominate the discussions. Your role is to debate and vote as an individual, but then respect and support the decisions of the majority. You must set aside your personal interests and influences for the common good, and be ready to move on once a decision is made, even though you don't entirely agree with the outcome. I'm going to give you an example of a decision at County Council that I didn't support at first. But in hindsight, it was probably one of the better decisions made. The lower tier municipalities all had their own economic development committees, and I believe that to be sufficient. County Council and staff decided that there should be a new county-wide economic development committee. With the foresight of Councillor Chris White and Councillor George Bridge and some amazing staff, the Wellington County Economic Development Committee was formed. It was a majority vote at the time that I didn't support, but when it passed, I accepted it and I moved on. Little did I know at the time, Wellington County would have one of the strongest, thriving economic development departments in Ontario and probably across Canada. It was done, so I'm having trouble seeing here.
It's so dark.
Yeah, it's really dark. Anyway.
Just look that light.
Is there a light?
Yeah, there are. Yeah.
Better, much better. The Economic Development Committee has done so much for businesses in the county. I wanted to tell you about that to support my statement about moving on once a decision is made for the common good. Any of you who know me know that I'm one emotional lady. I swear it's in my DNA and I can cry at a Bell telephone commercial. However, for the sake of the community, you need to be able to stay in tune with your own emotions. If someone tells you that you had the worst idea that they've ever heard, you must be able to withstand that criticism. Being emotionally mature means staying engaged and not overreacting. So, once you've made the decision to run for council, the next part begins. Campaigning. Putting yourself out there. Believe me, until you've tried, you couldn't possibly comprehend how hard it is to connect with citizens, to tell them something about yourself, and motivate them to vote for you. Once you're elected, you are considered a leader in your community. And never forget, leadership means listening carefully to understand concerns, ideas, and perspectives. You will be expected to be accessible to the community through meetings and events, by phone and by email, 24/7. I'm going to tell you a little story now about one of my campaign days. I always believed that the people that I was represented wanted to see me as the candidate or the candidate's family. So one evening I was just starting out and I wanted to talk to as many people as possible. So I was almost running from one house to another to knock on doors. My shoelace was untied. I stepped on it with the opposite foot and down I went, face first in a gravel driveway. I mentioned earlier that my daughter was a nurse practitioner and luckily she was helping me campaign that evening. My face was all scraped up, my nose was smashed, and my baby finger was broken. I looked like I'd been in quite a brawl. She took me to Groves Hospital, and I happened to run into two of the OPP officers there that I knew. They looked at my cut-off face and very innocently said to me, I thought the Meet the Candidates night was tomorrow night. The next night was the Meet the Candidates night, and my fellow candidates and residents teased me about trying to get the sympathy vote. Wellington County and some of the lower tier municipalities use the committee structure to get things done. One of the first things that you will do once you get elected, probably for the first time, is to decide what committees you want to be on. You want something interesting, but you want to be stimulated as well. Don't be shy. Maybe look at a committee that interests you, but that you're not too familiar with. Anything you can do to learn how the municipality operates is good for you and good for the people. I was fortunate through my years on council to be able to be a member of most of the committees. One of the many responsibilities of the warden is to attend each committee meeting, and that year I got a real taste of what each department did to ensure the county administered well for all the citizens in Wellington. I enjoyed my time in all the committees I served on, such as roads and social services, but I have to tell you, my time as chairperson of the Wellington County Police Services was the most satisfactory for me. I was excited to see each one of the new programs that were put in place for the protection and safety of the residents in Wellington. These programs made Wellington County a leader in countywide policing. I mentioned earlier that I wanted to talk to you a little bit about conferences and trade shows. If you are serious about your job as a council member, it is important that you get perspective from other councillors and staff in other municipalities. It is important to talk to others about things happening in your municipality, as well as in theirs. You will be amazed. Those problems are the same in most communities. They just involve different players. You will learn a lot from the different speakers in different forums, so I urge you to attend some of these conferences. You won't be disappointed in their value. One of the most important things you can do during your time in council is to get to know your staff and appreciate the knowledge that they have about the municipality and about the residents that you serve. And John had talked quite a bit about this, and it's probably one of the most important things as a councillor that you can do. There's no greater resource for you than the staff. They have knowledge on most of the issues that are presented to you as a councillor. I learned very quickly to talk to the staff when I needed more information on an item so that I could make an informed decision. One thing I would like to caution you about, and again, John had talked about this, but this is so important. Always remember, your position will be to govern. Their job is to put your decisions in place. It is not up to you to try to manage the operations of the municipality. When Amanda asked me to put together this presentation, I asked her how personal I could get. She told me I could get as personal as I want. So I'm going to take this opportunity to say thank you again to the CAOs, the clerks, and all the staff of all the municipalities. Without their guidance, I would not have been able to make the decisions that I felt were best for the residents of Wellington County. The department heads and all the departments and their staff worked tirelessly to make Wellington a better place. Be prepared. If you were involved in scouting as a child, that was their motto. It should be yours too if you are successful in your election. The staff work to get the information to you in your council packages and all the reports during the month. Read them. Be ready for the meeting you are attending. There's nothing more frustrating than attending a meeting and having others not prepared. You asked for the honor of representing your residents, so please make sure you do your homework. Being elected by the peers to lead the county as a warden was probably one of the best years in my life. It was the county's 150th year, and as well as running the county, we did many events to celebrate. We visited surrounding councils such as Dufferin, Region of Peel, Waterloo Region, Halton Region, and the City of Guelph. And I have to say, we bragged about how great a place Wellington County was to work, play, and live. I want to tell you about my very first council meeting as the warden. I took the warden's chair when I was elected. It was January 2004, the council meeting, and the decision had been made to dress the council as they would have 150 years ago. Most of the men looked very smart in tails and top hats, but I walked in a modern business suit because women were not allowed to vote back then. So, of course, there were no women politicians. The CAO announced, as he usually does, to bring things to order and start the meeting. Ladies and gentlemen, the warden. And in I walked. He looked at me, looked around the room, and he uttered, "Good God, it's a woman." It certainly put us all at ease. This is a good place for me to talk about dress code. The respect that councillors have, especially when at the council meetings, demands that councillors should be dressed accordingly. I always wore a business suit, and the men always wore shirts and ties. I know things are changing, but I think it's important for you to dress like you mean business, and not like you were at a casual event. The term when I was the only woman on council, I gave the gears to the men who showed up without a tie or were very casual in their appearance. Dressing in business suits is honoring the position that you have been given. Your key responsibilities as a councillor are to support the municipality and its operations while ensuring that the public and community's well-being and interests are maintained. So in summary, and again, this is my advice only, you will want to listen to what's going on around you. You will need to build a mutual respect with your fellow councillors. And it will be necessary for you to build a good relationship with staff. You must be available for the people that you serve. I loved my time in council. I loved knowing that I could get things done for the sake of the community. I love the friends and colleagues I made during my 25 years on council. I enjoyed getting to know many of the village and county residents and helping them with an issue if I could. As much as I cherished my time in politics, I knew it was the right time for me to retire. It was one of the most difficult decisions I had to make. And as much as it pained me, I knew it was time for the next chapter in the book of Linda White. Earlier, I mentioned that I'm a very emotional lady. Well, I can tell you, I spent many times after I made the decision to retire in tears and wondering how my days would be once I left political life. But I can assure you, there is life after politics. There's family, friends, and travel, many things to look forward to. I have time now to volunteer for some amazing groups that we have in Wellington County. As Amanda had said, I'm a member of the campaign cabinet for the Grove Youth Wellness Hubs in Wellington. I'm also privileged to be a member of the committee who brings awareness of the problem of human trafficking that we have here in Wellington. I joined the Rotary Club, and I'm a member of 100 Women Who Care. Even though I have been away from the political life for a few years, I'm always following what's happening politically in our municipalities. Life is good. I still miss the people I've met along my political journey, but I know where most of them are, and I just have to reach out and say, good day. I wish you all luck in this chapter in your life, and if I can leave you with this thought, be kind, be respectful, and be dedicated. All the rest will fall into place.
Thank you so much, John and Linda, for your excellent presentations. So we'll now take questions from the audience. Please indicate to whom you're directing your question. If you're on the fence about asking a question, I would encourage you to ask it, because there's likely someone else in the room who's thinking the same thing. So the microphone is on. If you want to go up and ask your question, John and Linda, I'm sure will be happy to answer.
My first is not really a question, kind of just a quite a few
few years ago, I picked up the phone and I called Linda and I said, how do I sit on the Wellington County Police Services Board? And she gave me the path of how to apply, and I was made Warden and Counsel that I sit on today. And I've loved every minute of it. So I'm here tonight because I will be running. My next true question is for John. When counselors behave badly, is it, you know, whether it's comments, speaking ill to staff at a township level, wouldn't the mayor or warden handle those things first before it would go to an investigation?
Yeah, that's a really good question. Yes, if it happens at a meeting.
Yeah.
In fact, there are a number of integrity commissioners, I'm not one of them, who will say, it happened at a meeting, I don't have jurisdiction. I don't believe that's the case, and I'll tell you why. Sometimes you have a weak chair. Sometimes you have a chair that's aligned with the person who's behaving badly. It should be dealt with properly through the procedures of the meeting. And again, I referenced the procedural bylaws, so you should know that if something happens at a meeting and you don't think it's appropriate, the person's overextended themselves, done the wrong thing, then you can call a point of order. So become familiar with your procedure bylaw. But your point is really good. The council itself should be policing itself there. The chair should have control. Again, we don't have speakers per se. We have, like they have at the federal, provincial levels. City of Toronto has a speaker, but you have the chair, and sometimes the chair is just not doing their job. So I have occasionally ventured in because I'm seeing what's happening. The council member's behaving badly, has gone in cahoots with the chair's letting them get away with it, and so I feel that something needs to be looked at. Otherwise, I would say, yeah, whatever happens at a meeting is really governed by the procedure at the meeting. So that's a really good, astute point.
And that's what I'm seeing too across the province, really, just because of what I deal with in one of my roles. And I often wonder, why didn't the mayor say anything? Or is it appropriate for another counselor to say something, you know, that's sitting beside a person? Because I know for myself, I would want to say something like, that's not appropriate, can we move on? But yeah, I'm finding the people at the helm just are not, or they're afraid.
Yeah,
Yeah, okay,
I agree.
okay.
Thanks for the question.
Thank you, that's all.
I can feel the questions brewing. Yes, there we go.
And we want women to run.
Okay. Yeah, hi there, my name is Ed O'Shaughnessy. Actually, with your question before, I couldn't help think about what happened recently in Guelph with
Yes.
the comments there, but anyway. My question actually is, you talked about the Integrity Commissioner being responsible for education and training. If somebody is running for the first time and is going to be interested in being a new councillor, can you talk a little bit about what might be involved in that education and training?
Sure. Usually there is some orientation. I know as Integrity Commissioner, I often get asked to do an orientation session. And I always say, that's not going to be enough. I'm going to need a good 3 hours, run through the code of conduct, explain how things work, and the municipal conflict of interest. You just got like a little snippet today. But yeah, there should be some real hard training. I think integrity commissioners have taken a sort of a pretty strong stance on that. It does no good, believe me, the last thing I want to do is go and investigate. It's not nice work. You will usually end up having everyone, you never make anyone happy. The complainant feels, I want the person off council, right? Well, we can't do that. The council itself can't do that. The council member feels that they're being picked on. Maybe the person who's made the complaint is a constant complainer, is a political rival. Doesn't mean that their complaint is incorrect, right? So the preventative medicine that can be given through way of education and training, I think, is absolutely essential. Most of my councils have bought into it. I'm going to be really booked, I think, in January and February, to do council training for that type of thing.
Okay,
Yeah.
I just kind of wondered how how formal it might be, that's all. And it sounds like there is some formality to it.
There is. If you do become elected, then you should ask for that. Just, say, I think we need to have that. I mean, some of these things can get you off of council, right? And so you need to know about it. It does no good for the municipality to spend hundreds of thousands of dollars. Believe me, these conflict of interest applications are not inexpensive. $100,000 is not an unreasonable amount to go and spend to try to defend yourself or to bring one.
Okay, all right, thank you very much.
Great question, sir.
Thanks.
Hi there. This could be for Linda or John, I'm not sure which. And by the way, John, that first quote, I would love to be able to see that again. If I can get, that was a great quote in your presentation. I watch council meetings, and I'm just curious about the process of decision making. And I see staff would come and say, here are 3 options, or 4 options, or it's a yes, no. And then I listen to people, citizens come speak, I hear councillors speak, and then I'm listening and I think, oh, there's a solution here that could work for a lot of people. But yet then it always comes down to a yes-no decision or just 1, 2, or 3. Is there any process where you can just say, oh, let's just stop here, let's have a little committee over here, and let's have a little chat, I think we can come up with a better solution? I don't know. Does that make sense?
Linda can probably tell you some real life situation. Here's the thing, and she said that staffs spend a lot of time getting you the information. What you have to remember is maybe a lot of that discussion has already taken place. It may not be apparent to the public who are seeing it for the first time. They're thinking, oh geez, they're making a $40 million decision in half an hour. You don't know all of the work that's gone behind it. There may have already been committee meetings and things. So it is possible, but otherwise the machinery of government would ground to a halt if you had to have a subcommittee. But I understand your point as well.
Because it's always like sort of 3 options, or are you allowed to modify an option, or say, I want a bit of 2 and a bit of 1, a la carte.
There again, it's always been a decision of the majority. So we are lucky we live in a democracy where people can make decisions or not agree with decisions. But my experience is that when the councillors talk about a decision, they've already talked to the staff, in most cases, they've talked to the staff, they've read the information that they've been given, and they try and make the best decision they can for the group. And then, like John said, if you didn't make a decision, things just won't get done. So I know there's always what ifs, but I think for the good of the community, these decisions have to be made. Not everybody agrees with them, but they have to carry on. And if it comes to a point where somebody really, or a group does not really agree with it, they can always approach their councillor.
Yeah, I'm not saying like it's sort of like adversarial, I'm not talking adversarial, I'm just thinking if you really listen and citizens present, and you hear all the different points of view, some for and some against, sometimes there's like something that could be modified that would suit everybody. That's sort of what I'm getting at. I just wonder if there's any process for that. I guess there isn't.
Yeah, well, I guess there is, because if people don't agree with what's going on, it's many times when we were in council, we would say, okay, we just can't quite get to a decision, we're going to send this back to staff.
Oh, okay.
And they can come up with more information, or tell us. Many times our motions were sent back to staff, and then they were brought back at the
And
next
does a councillor make a motion to have that happen? Okay.
Yes.
Okay,
Yeah.
thank you.
Linda, you might want to stay there. Just a question, you mentioned on campaigning, so are there rules around us campaigning with fundraising or whatever it is we can do, signs, what we can do, and where do we find that, just to, as we look ahead?
There are definitely rules, and you need to talk to the municipality that you're your campaigning, and I'm not sure what, it used to be signs could go out after, about 6 weeks ahead? Yeah, but, yeah, there's definitely a lot of rules that you need to adhere to, so.
Are the municipality what to run that they'll have those rules?
Yeah, they will have everything for you.
If I could just say one other thing, that there is a really good resource from the Ministry of Municipal Affairs on candidates running for election. It's a really great handbook that sets out the rules in a very readable, easy way. I often go to it because people will ask me questions and I won't know. I'll look at the legislation, so I go back to it. So just go to the Ministry of Municipal Affairs and Housing website and look up elections, and they'll have some great resources. Amanda, I can't remember the name of it, but it's a guide to...
There's a voter's guide
Voter's
and a
guide.
candidate's guide.
And a candidate's guide, so really great, and there are tons of rules, there really are. Most of them are in the Municipal Elections Act, but each municipality has its own procedures as well.
Excellent. Maybe just to build on that, thank you to the clerks for organizing today. Thank you for all for being here, for offering to run, for resources. I just want to let you know that we do have some resources available locally for candidates. I encourage you to go to municipalcampaignschool.ca. That's municipalcampaignschool.ca. Lots of great resources on there for female and other equity-seeking candidates in particular. We've designed it. We're all volunteer-based. No agenda except to diversify the voices around our council. So you'll find lots of videos on there, lots of the resources that John was referring to. Municipalcampaignschool.ca will send you to lots of other places where you can find resources to help you get your campaign up and running and start your plan to win now. So I just want to share that with everyone. Once again, what's the website? Municipalcampaignschool.ca. Yes? All right, thank you.
Personal liability. So how does D&O work for municipal buildings?
Yeah, there is a general immunity set out in the Municipal Act, Section 448, that says if you act in good faith, if you carry out any action in good faith, or don't take an action, as long as you're acting in good faith, then you're immune. That doesn't make the municipality necessarily immune. The municipality may still be vicariously liable for something that happens, but the municipality will often purchase insurance for council members to ensure that if you're sued and you need to defend yourself, that you'll be covered for those sorts of things. I can't tell you specifically which municipality, what's covered. I certainly know we talked about the cost of defending or even bringing an application under the Municipal Conflict of Interest Act. Most municipalities have a rider in their insurance that covers the cost of up to $100,000 as long as you're not found to have contravened the act, okay? So, and that's why often we get lots of resources thrown at us and defenses made when we bring applications against members for the breach. So there is insurance coverage, but there's also a statutory immunity if you've acted in good faith.
Thanks.
John and Linda, thank you very much for presenting here tonight. My question is for Linda. I understand the need for family support in running for municipal politics. I've asked my wife to come and be here with me this evening. If you could just explain a little bit more what I could expect as a time commitment in being a municipal councillor. You spoke about preparing for meetings, you spoke about attending committees. Can you just explain a little bit more about what the time commitment looks like and maybe what my family can expect through this journey?
Depends on the municipality and how much information that they have presented at each council meeting. I can't remember, council meetings are twice a month, usually, and most of the, and you're looking at either a full evening or through the day, just depending on what the council has decided on. Time preparing at home, I would sit on my sofa with a and read my council package, probably 2-3 hours sometimes at a time. So there was a lot of reading to do if I wanted to be prepared for the meetings that I went to. There are councillors who go to meetings, they're not prepared, they haven't even opened their council packages, but like what's the point of going if you don't know what you're talking about? So time commitment, it's not like you're going to miss a dinner with family, because you can change things around or anything, but you will be spending time reading and talking. And the one thing that you need to realize is too, the people in your community, they feel that they can call you or try and get a hold of you anytime, 24/7. You have to be available. And I know many times I was just walking down the street and people would stop me and ask me a question, and so you have to be prepared for that. So it is a part-time job, but you have to be dedicated to the time that you give. A lot of people have said to me, you can give as little or as much time as you want. Depends on what kind of a job you want to do.
Okay, thank you.
This is for John. I have an affiliate, or an individual I know, who was charged, was found in contravention of the, like the integrity contravention. And the problem I have is he didn't know who his accuser was. That seems to reduce the relevance on the charge. It seems not to, in my mind, it just doesn't seem to be an appropriate thing to do without knowing who your accuser is.
Sure. That's an interesting question. We get that a lot from councils. Now, a municipal council can itself set up a complaint protocol as to how it would like the process to be followed. And one of the things that they could do, which I do not recommend, so I'll be clear about that they could ask for the disclosure of the identity of the person who's filing the complaint. I think it's a bad thing. I've been an integrity commissioner now for 8 years. I think most complaint procedures are all confidential. The fact that you have an independent, impartial person who's looking at it will make an assessment. Is this a valid complaint? Is the person bringing this frivolously? Is the person bringing it vexatiously? That's an assessment that we always do when we're looking at an intake matter. In most cases, you don't need to know who the complainant is. I'll give you an example. We had, one of the first ones that I looked at was a terrible member of council down in the Niagara region, who had posted what I would very close to calling the police on, looked very much like hate literature. It was on his social media. He had on one page a picture of Muhammad. Now, whether you can even do that, depict Muhammad, and sorry, had a picture of Jesus. I should start with a picture of Jesus, and the words were love, understanding, empathy. And then the next slide was a depiction of Muhammad that said pedophile, murderer, rapist. That's a bit of a problem. Someone saw it and made a complaint. He said, I want to know who made the complaint.
That's the problem with your bias.
With my bias?
Yeah, exactly, yeah. Like, I'm not gonna make judgment there, but there is a bias there.
That,
like, he has a bias, but you're repeating that bias in reverse, if you will.
I don't understand that, but
yeah, like you're expressing a bias. You're expressing a bias.
I'm expressing a fact.
Yeah.
Which is a fact. It's not a bias. I disagree with you. So
we do have an element of free speech in this country.
We absolutely do. The Charter of Rights.
That's right.
It's not absolute. Subject to such reasonable limits as are authorized or in a free and democratic society. By the way, Justice Edwards talked about that in a case called Buck versus Morris. Have a look at that case. Buck versus Morris was about 10 years ago.
I do have an issue with the not knowing who your accuser is.
I understand that. I don't think you need to know who the, my point was, you don't need to know who the accuser was. It was on social media. What difference does it make who's
No,
on?
no, I'm talking about difference, that you're talking about that situation.
Okay, I gave you an example. So
Yeah.
let's say the situation was someone was harassing someone else. I think the only way you could actually defend or respond to that was to know who the other person is. I understand that point,
Yeah.
right? So if that's the case, in most instances, as an integrity commissioner, I would say that person can't make a justifiable response unless they know who it was. But in most cases, you don't need to know who it is. So again, it's up to the municipality to make its decision. But most complaint protocols do not require the identification of the accused. Why? It would have a chilling effect. Person is afraid of reprisal and other instances of having their name made known.
But, like, I don't really want to go to the charter, but isn't it in our Charter of Rights that we are entitled to know who our accuser is?
You're talking about a criminal situation, and that case was dealt with in DiBiase versus the Vaughan Integrity Commissioner, where the court said, in a criminal case, you may be imprisoned. You may be imprisoned for life. You need to be able to have full disclosure of all the facts. What are you looking at in a code of conduct matter? You're looking at a slap on the wrist, which is a reprimand, or a suspension of pay for up to 90 days. Completely different facts. So they said it's on a spectrum. Procedural fairness is on a spectrum. In that case, they said very clearly that no, the person who is being accused of having breached the code of conduct does not have an entitlement to know everything about the case.
My counter to that is, wouldn't that encourage frivolous accusations?
It may, and that's why you have an integrity commissioner who's hopefully experienced, knowledgeable, and impartial, who will look at that and consider something like that.
Thank you.
Yeah, thank you. We're just getting started.
Great presentation so far today. I'm just going to go back to the very beginning about the qualifications to run for council. So myself, my whole family, my life, everything I do is in Wellington North. Or even my address would indicate that I live in Wellington North, but I'm on the wrong side of the sign. Does that mean that my wife and like my spouse, myself, don't have any residency in Wellington North, but everything about us is Wellington North? Like, I have nothing to do with the county that I'm in. I'm just on the wrong side of the sign, and not by very far. Like my address, I have to go to Wellington North to get my mail, right? Like everything. Does that mean I cannot run for Wellington North?
Yes, unless you lease some space. Now, I don't know what that actually is. Like when I say some, there's nothing that says unequivocally you have, but you may.
Like would I have to rent like a certain size of space?
That's just
do I have to have that space for so long before I can run?
No.
Or could I go get some space tomorrow and still be okay? Or?
Yeah, nomination period starts on May the 2nd. You can sign a lease, and you could have commercial space, or, people have asked me, how about a self-storage unit? I said, I don't think so, but it's one of those, I think it has to be some sort of real use, like office, commercial institution, something more than just parking some old furniture.
Yeah. So
Did you have a public mailbox?
I've been asked that, and I said, I don't think that would pass the test, but...
Like, I'm so involved with my county,
yeah,
right? Like, I'm very involved. It's just like, how do I make myself part of the county? Because, like, I'm pretty much there. Just, I guess that residency part is my situation, right?
Yeah.
So is there a list of what I cannot do, or... Like to get that residency, so I don't want to go rent something and be like, well, that still doesn't qualify, right?
Yeah, so the best advice I could give to you is you should get an opinion from, see if the municipality will give, they probably say, oh, this is on you, you have to figure this out. And a lawyer might be able to give you an opinion. I've been asked about the mailbox before, and I said, I don't think that'll pass muster. I said, I have unease with a self-storage garage unit as well. Even though, you do rent those, right? Like you have some sort of rental agreement for those. So I suppose someone could make the argument that that's sufficient.
But could I rent an apartment and sub-rent it?
Yes?
Right, that would give me my.
Yeah. Yeah.
All right, perfect. All right, thank you very much.
Thank you. Another satisfied customer.
Great. Thanks again, John and Linda, for your excellent presentations, your fantastic presentations, and taking the questions this evening. Before we adjourn for the night, I just wanted to let you know that unfortunately the Ministry of Municipal Affairs and Housing was unable to join us tonight, but they have provided copies of their presentation, which can be found at the back of the room. There are also packages and resources from each local municipality that you are welcome to look at and or take upon your departure, and say hi to the clerks on your way out. On behalf of the Wellington County Clerks, thank you so much for joining us this evening. Take care and get home safely.